Welcome to Radcliffe Chambers Real Estate, Radcliffe Chambers Real Estate first seminar, Radcliffe Talks Real Estate. And this is a series of short webinars hoping to give a quick update on matters that matter to clients. And the first in our series, Rating and Valuation 2021 Revaluation Postponed, Reliefs, Temporary, Mandatory and Discretionary, Material Change of Circumstance Challenges is the topic. My name's Clive Moys. I'm a barrister practicing at Radcliffe Chambers, and rating and valuations is one of my specialisms. I'm absolutely delighted to welcome Tim Johnson of CBRE, a senior partner in the Property Tax and Rating Group. Good afternoon, Tim.
Good afternoon, Clive. Good afternoon, everybody.
Would you like just to say a few words about your practice, Tim?
Yes, thank you. I've been a rating surveyor for 25 years. Most of that time has been spent with CBRE, and I can't remember a time where business rates has been more newsworthy. So a very topical webinar.
Excellent. Thank you for that, Tim. Well, to give people the shape of what's to come, we've got our three topics, which I thought we would take in this order. The first topic will deal with the various reliefs, temporary, mandatory and discretionary, touching upon grants and a little bit about mitigation and a couple of important cases, I know one of which you were involved in. Then we'd look in the middle, as it were, at the 2021 revaluation that's been postponed, which I think will probably be the shortest piece. And then thirdly, the very important topic of COVID-19, material change of circumstance, and proposals to alter the rateable value based on that. And hopefully we'll wrap it up with three takeaway points for our audience. Welcome everybody. I'll just, if I may, set the scene. Criticisms of perceived failings of non-domestic rates often intensify as one list draws to a close and another list, the work on another list indicates the increase in rateable values, which will then be reflected in bills on the 1st of April. And of course, just going back a little bit, the 2017 list was a postponement from 2015 because we're emerging from the 2008-9 recession. And again, we had a system of adjustments, tinkering. And I think, Tim, it's fair to say that the reliefs and transitional arrangements are rather complicated, to put it mildly.
Yes, you're absolutely right.
But I think it's fair to say designed to some extent to impact on mitigating the bottom line of losers, as it were, and soften the criticism of NDR as a form of taxation. Tim, is there anything in particular you would like to pick up on in terms of the 7-year life of the list that we had most recently in terms of transitional arrangements?
Well, I think one thing that we have learned as a result of the revaluation in 2017 is just how inequitable transitional relief can be. Yeah. Now, I think we've had a scheme ever since the sort of current non-domestic rating from 1990, and the upwards winners, if you like, are always paid for by the downward losers, so it's fiscally neutral. Yeah. Your liability is phased up according to how much your rateable value has increased. For 2017, the downward steps are really quite punitive. So one could see a doubling of one's rateable value, and yet your liability only went down by 2 or 3% because of the way that the scheme was constructed. Yeah. Now, that has caused immeasurable problems, particularly in certain property classes, and I'm thinking of retail and especially in the Northwest, where you can see your rateable value go down by 50%, and yet your liability is still linked to something, rental value back to 2008. So it's been problematical.
Thank you. Just on adding to the mix, as it were, of course, we had the new check challenge appeal system introduced in 2017. I think it's fair to say quite a lot of criticism about lack of consultation and engagement by those that actually know how it works, the system with the old system of proposals, and problems with the platform, problems with, or in principle, and the onerous front loading of the process. Do you just want to comment on that? But we're going to pick it up under our MCC section.
Yeah, the CCA has come in for a lot of criticism, and a lot of it is right. There is a lot of bureaucracy, and there have been lots of issues registering on the government gateway and getting access into the system. The timescales are long, but it is the system that we've got, and we are going to have to work with it. And I think COVID-19 has given us a good catalyst to find out what the problems are and really where we can make improvements and get the thing working.
Thank you very much. And just to add even more into the mix, of course, there's another fundamental review of the whole system of national non-domestic rating that the government announced, with very wide-ranging terms of review. But of course, COVID-19 struck, and the government, the Treasury swiftly, as we all know, swiftly legislated for lockdown with the 2020 Act, announced the new relief in relation to retail, leisure, and postponed the revaluation until the 1st of April 2022. So that's really the picture, I think, against which we come to take our three topics. So Tim, if we can first of all turn to reliefs, temporary, mandatory and discretionary. I think a complicated patchwork is not an unfair comment in relation to reliefs overall.
I agree.
Well, if we descend into the detail, as it were, the multiplier, of course, has been creeping up in the life of this list. I think 2020 to 21, and we're now at 51.2p in the pound. So as it's creeping up, the reliefs are ever more critical, I think, for the bottom line of occupiers, owners, etc. And of course, the small business would multiply a little bit smaller, 49.9 if you're under 51,000 RV. Tim, so let's take the big relief, the temporary new relief, retail, leisure, hospitality, 100% relief for the whole of this year, holiday announced by the Chancellor very quickly. I think you'd like to comment in relation to some of the big retailers and also some of the other sectors, services, offices, perhaps. What would you like to say on that topic?
Well, I think the first thing to say is that credit needs to be given to the government for acting swiftly. And really, as soon as COVID-19, the reality started to hit, then the announcement of 100% relief for 12 months for retail, leisure and hospitality was brought in quickly and swiftly, and it does provide genuine relief. I think that the criticism is that it's indiscriminate. So if you're a Tesco or a Sainsbury, you're trading as well as you ever have done, and yet you're not paying business rates. And I think the other main issue is that it doesn't affect anybody else. So if you don't fall into that retail, leisure or hospitality sector, irrespective of how COVID-19 has hit you, you're getting no relief whatsoever. And I think that has caused a number of issues.
Thanks very much, Tim. So just running through the reliefs quickly, just to remind people of what is out there and what's available. We've got charitable rate relief for charities and registered amateur sports clubs, 80% mandatory, they can both apply for it, section 45.6. The discretionary part, 20% on top. Of course, how billing authorities will react to applications for discretionary relief in these difficult times is another question. We've got 100% unoccupied empty relief, 3 months void period, 6 months for industrial and storage, and those with RVs below 2,900 are exempt from empty property rate. We've got the small business rate relief, 100% with an RV of below 12,000, and then a taper up to 15,000. Is there a comment there in relation to those that are above the small business relief, but not in one of the categories that have been given the holiday?
Yes, there is. I think, I mean, the government have also announced a series of grants which are either 10,000 or 25,000, but they're aimed very much at small business. So again, a vital relief for them. But if you fall outside of that, there really isn't anything. So I think what we're concentrating on is empty rates or unoccupied property, and there's two strands of this, which is the wholly empty, where one gets 3 or 6 months nil rates upon vacation, and then there's partially vacant, which is a discretionary relief through Section 44A of the Local Government Finance Act. Now, I think pretty much the vast majority of properties, commercial properties across the country, have experienced some form of vacancy because of COVID-19, and particularly if you're in an office environment, and central London is where we are and work, and is being particularly acute. So what can one do in these circumstances? Now, empty rates provisions are fairly strict, and there's lots of legislation and case law backing it up. And to qualify for empty rates, the building has to be entirely vacant. Large items of furniture can remain, but crucially, IT needs to be powered down. So if we reach a point where we've been forced to vacate because of COVID-19, we've got lots of empty office space, but can we get empty rates relief? And I think the unequivocal answer we're getting from the vast majority of local authorities is no, that simply by removing people, you've still got all the stuff there. So empty rates won't qualify. We then have to couple that with financial services and IT as being key workers, and the buildings could be accessed. So it seems to me that empty rates claims, where all that's missing is people, are likely to be doomed to failure. Similarly, Section 44A is where there's partial occupation. The same rules apply, that you need to be cleared, but again, you might be able to identify such areas of space. I mean, I'm thinking about maybe canteens, auditoria, large spaces which were cleared and had to be cleared and couldn't be used. Now, there may be opportunities for Section 44A relief there. One has to make an application to the billing authority, identify the area, and the dates. But the key thing here is that it's a discretionary relief. So entirely at the discretion of the local authority. Some local authorities exercise their discretion absolutely and don't grant it whatsoever. Others take each case on its merits. And I think that's the messaging around this, that the series of reliefs are quite complicated, and there's lots of them. And the situation on the ground is going to vary from occupier to occupier. So I think it's a case of what's happened, let's have a look. Can we apply for reliefs? If we can, then we should. But I don't think there's necessarily a one size fits all here. It's different measures for different properties.
Thank you very much, Tim. And of course, we've also got rural rate relief in relation to small settlements below 3,000 people. You've got a general store, post office, food shop with an RV of less than 8,500, or the only pub or petrol station RV less than 12,500, 100% relief from the 1st of April. So that's relevant for some clients. You mentioned the small business grant. There's the possibility, of course, of deferring payments. I think some billing authorities may take a slightly more sympathetic line to that. But as you say, it's once we're in the realm of discretionary relief, it's difficult to know necessarily how it's going to be received. Tim, if we can just touch on the case law briefly in relation to mitigation. If we look at the Woolaway, let me just get the case. Sorry, Newbigin and Monk. If we look at that briefly, first of all, Supreme Court case, to some extent, we've been spoilt rating surveyors and lawyers in the last, I think since 2015, we've had at least 4 cases in the Supreme Court that I can think of, together with a piece of legislation as well. So interesting times to be in the world of rating, as you say. Newbegin and Monk, I mean, the way I put it is reality principle trumps the statutory assumptions, and it's a win for occupiers, owners, developers. Can you just explain how you see Newbegin and Monk?
Well, very much so. Yes, it's how one's property, what happens to one's property when it is undergoing a state of refurbishment, and it's the physical condition, and how much rates are payable. Allied to Monk and Newbegin, there was a follow-up appeal in Canary Wharf versus Jackson, which went on to consider these issues in a little bit more depth, because the Valuation Office claimed that there had to be a scheme of works in order for a property to be taken out of rating. And this was an upper chamber decision, which largely upheld the Supreme Court, that if you take a property back to a shell and a court and make it incapable of occupation, beneficial occupation, then a deletion or an RB0 may be the appropriate outcome. Yeah. In this case, Canary Wharf stripped their offices back to a shell, and they then leave it until a tenant's found, which is good practice. They can do that because they have an in-house development team. The Valuation Office said that no, there's no scheme of works there, but the upper chamber said that we're following the Supreme Court. There doesn't need to be a scheme of works. If something is unfit for is incapable of beneficial occupation, then it should be deleted. And it seemed to be fairly unequivocal in that respect, that if you take it back to a shell, you won't be paying rates on it, irrespective of how long that condition stays.
So one could regard it as both a common sense approach and also consistent with one of the four fundamental aspects of rating. It's got to be beneficial occupation, and that, in that case, incapable of it. Then I just want to touch briefly on the Property Alliance group of cases, or cases involving Rosendale and Wigan councils. That was in 2019, Court of Appeal decision on the 7th of March of this year. In essence, the billing authority's attempt to either pierce the corporate veil so as to get past the SPV, which had been granted a lease of the premises, was unsuccessful. The leases weren't shams, and nor was the application of the Ramsey principle, which is a taxation case from 1982, mean that the leases could be disregarded, so that, again, the billing authority couldn't get behind the SPV company and charge the owners with unoccupied business rates under Section 45. It's quite technical, but the reason being, of course, that the four elements that are required for unoccupied liability under Section 45(1)(d) requires the hereditament to be in a class of property specified by the Secretary of State. And under the National Non-Domestic Unoccupied Property England Regulations 2008, Regulation 4, little h, hereditament whose owner is a company which is the subject of a winding up order under the Insolvency Act 1986, or which is being wound up, whether members voluntary or creditors voluntary, is an exempt property from being, so it's a sort of a double negative, but it's a result which apparently there are £10 million worth of test cases pending on that decision. So be interesting to see how that develops in the future. Tim, thank you for that. That's our first topic. So if we now turn to our second topic, which is the revaluation postponed, which we touched upon in our introduction. I think really occupiers, owners, developers will all be interested for a variety of reasons in this, and there will be winners and losers. Tim, if we just cast our mind back to the 2010 list, which wasn't revalued until 2017, we can look at some of the winners and losers during that period. And I've got London retail was up 26%, offices up 22%, industry 15%, other 26%. whereas in the southeast was up 9 overall, whereas in northwest Yorkshire and Humber it was 0. Can you say how, first of all, how you regard that and in relation to transitional relief, and then about what that might tell us in the next list that's coming?
Yes. Okay, so the current 2017 list is rateable values are based upon rental levels in April 2015. Now, the 2021 revaluation was going to be based upon rental values in 2019. So clearly what rental values had done between 2015 and 2019 was going to dictate where one's rateable value went. And I think generally central London rents had gone up pretty much across the board, a little bit of movement in the southeast, and then across the rest of the country, largely stagnant, apart from retail, where there are areas which have gone down sort of quite substantially and have done for a number of years. So a postponement of the revaluation, I think, means that London properties will enjoy a further year of paying rates based upon 2015 rents. Everyone else kind of misses out, and they need their revaluation so they can rebase their rateable value, but have got another further year of what they're currently paying, subject to that usual inflationary increase.
Yeah.
So it just sort of keeps everyone in limbo for a further year. With regard to the 2021 revaluation, or the revaluation that will follow this one, we're really very short of information. What was going to happen, that the government was proposing a revaluation cycle of 3 years, yes, with an APD 2 years prior, which was something which the industry has been calling for a long time. Shorter revaluation cycles so that rateable values can keep up with the market. It was a very good and sensible way forwards. What we have now is a cancellation, and we just don't know what's happening. The Valuation Office was mandated to do a revaluation with a valuation date 1st of April 2019, and they have largely completed that. So we have set in statute our valuation date, but we don't have a rating or a revaluation period upon which to hang it on. We know it's going to be delayed, but we don't know when. 1st of April 2022 would appear to be the natural progression from a 12-month delay. But again, we don't know how long for, and we don't know if that start date is going to be correct. It seems to me that valuations are expensive and take a long time. So that 1st of April 19 valuation date is likely to stay, and then we'll have a 3-year valuation from April 2022. That's my opinion, and it seems to be shared, but again, we just don't know.
No, thank you. And in terms of winners and losers, again, with relation to transitional relief, how would you see that?
Well, I would hope that the government would actually listen to us this time, or listen to industry this time, and they would deliver a scheme. They have done in many previous revaluations, where it's that much more equitable. That if you see a large fall in your liability, I think people can accept a phasing, but it needs to be sort of meaningful reductions in liability year on year. So, I mean, even if that imbalances the fiscal neutrality, I think we have to reach a point, particularly for retailers, where your rate payable is much more aligned to your rateable value, and transitional relief doesn't impact negatively year after year. There will be a consultation, and yes, that's due any day.
It does seem particularly iniquitous that you end up paying, you get a reduction and then you're subsidising the winners in a sense. But there we are. It's the system we have to work with at the moment.
Life isn't fair.
Tim, excellent. Thank you. Now, if we could move on to our third and final topic, COVID-19, material change of circumstance. Uncharted territory. Just to put the specifics of the legislation into the context, as it were. Regulation 41B, non-domestic rating, alteration of lists and appeals, England, regulations 2019. And I should just say differences in the nations, because rating is devolved, so we're not talking here Scotland, Northern Ireland or Wales, provides that an RV may be reduced due to a material change in circumstances which occurred on or after the day on which the list was compiled. And we know the current list was compiled on the 1st of April 2017. Tim, obviously coronavirus is an unprecedented event, and we had the Coronavirus Act, as we know. The statutory matters that may be considered in relation to material change of circumstance are rather complicated, I think that's fair to say, focusing in paragraph 2.7 on the physical state, physical enjoyment of the hereditament, the locality, user, and whether something's not affecting the physical state of the locality, but nonetheless physically manifest there. It can all get almost esoteric, perhaps,
yeah.
Yeah. First of all, and one of our questioners asked about this, what's your understanding of the VOA attitude and engagement?
Okay. Yeah, it's a good question, and really the very first question that we ask ourselves is a global pandemic physically manifest? If it is, then it's a material change of circumstance. And I think we both sides, both the valuation office and private practice, realise that this was unprecedented, as you've already said. So how does one deal with it? And of course, when one doesn't know, one goes to a lawyer. And that's, I think, what we did. So the valuation office took advice, individually a consortium of rating agents similarly sought an advice with various questions, but the first one, upon which everything else hangs off, is COVID-19 and material change of circumstances. Now, whilst the valuation office has been sort of keen to engage in the process and still wants to engage, they're not going to share their opinion. Likewise, we won't be sharing ours. But I think one thing that has come through is that both sets of opinion came back as, yes, this is a material change of circumstance. So I think we're over the first hurdle, if you like. We know that legally we are dealing with an MCC. And so the next question, which naturally follows, is, well, what's it worth? What happens to the value? Shall I go on?
Yes, please, Tim, because it's rather complicated.
Yeah. So the material change regulations are, as you've said, complicated. And there's lots of legislation underpinning it all, but I think we know that we're dealing with a material change. We've got two matters which we look at, which are those internal to the hereditament and those external to the hereditament. And what we ultimately trying to achieve is, what's the effect in value? If rental values are affected, then rateable value as an expression of rental value should similarly be affected. So that is the $6 million question: what's happened to values? Now, we do need to bear in mind that this affects every property class across every geography. So there's an awful lot of information that's going to need to be compiled and put in appeals and presented to the valuation office. Some property classes, I think, are going to be a lot easier than others. A car park, for example, which is valued on its trade, will be able to say that, no, everybody was locked down, nobody was driving, trade went to zero. And it's therefore, I think, slightly easier to demonstrate that there is a loss in value and a rateable value reduction should follow. If we're looking at something like offices, then it becomes slightly more nuanced and a little bit more difficult. We've got the external factors such as infrastructure, rail, buses, all of that network not working or not running. We have cafes, pubs, restaurants all closed. So they affect the use of one's offices, but they affect everybody. We've then got the internal issues, and of course social distancing is going to be quite profound. How does one use an office, particularly if it's of some size, where people have to be 2 meters apart and you can only get 4 people into a lift, one in each corner? They are the issues that we're dealing with, and we then have to put that into, well, what's the market doing? Are rents affected because of all this? And I think the only way we can know definitively is how the market reacts. If the market falls significantly, then I think we have a case, and that is what we have to present to the valuation office. The issue, I guess, here is going to be timing, because of course the market's going to take some time to react. We're going to need that time to build our case. So whilst the valuation office is keen to engage and wants to engage, we can't actually do it until we have something to tell them. So it's really going to be a case of, well, let's build this information, build our databases, see what the market's doing. Very important that our clients tell us what's happening. Have you got surplus space? Are you trying to sublet it? What are your prospects of subletting it? What's the rent going to be? Equally, are you getting rent concessions from your landlord? All of this sort of stuff adds to our database of evidence, which we will work up into a case and we'll take to the valuation office. We'll be doing it as soon as we possibly can, but I think the reality is it's not going to be until the end of the year that we're starting to get a feel for the valuation implications.
Very helpful. And in terms of the new world of check, challenge, appeal, how does that fit in with what in the old money was called a proposal?
Yeah.
How do you see that and getting them information to the VOA?
Well, I think in terms of lodging a check or starting the appeal process, for material change, the date of submission has always been important. It was important prior to CCA and it's equally as important now. So in terms of material change, the date that the valuation office acknowledges your proposal locks down the physical circumstances. So what we're trying to do is capture those when they're at their worst. Now, lockdown, I'm assuming now that there won't be a second spike, but things won't get worse than they were in lockdown. That was the worst period of time. And so if one lodges an appeal during that period, then one locks the physical circumstances at the date the check is received and acknowledged. Now, a check can be lodged any time throughout the event, and bearing in mind that we're going to be social distancing for some months, it would appear, then that window is still very much open. But I think as with the passage of time and the easing of lockdown and what happens, more shops open, pubs open, then the effects start to become less profound. So the later you put your check in, then it's the date that you put it in that you lock the events. And of course, if you've got shops open, pubs open, then the effects are going to be that much less. So any reduction in rateable value would be proportionate to that. So I think the messaging around here is that, okay, shops are open for the day. We've kind of just taken our first step back from the worst, but very much the window is still open. And my recommendation is get in quick. And may I just say sort of one final thing here. That yes, I'm here to save my clients money in their business rates, and my recommendation is a strong yes, lodge the appeal. But there is a moral issue here, and I think some of my clients have said to me, "Look, Tim, we don't want to be seen to be profiting. We're doing okay. We don't want to be a burden on the government." And we don't want you to take any action. And I think I respect that. And so there is that moral consideration as well. So these are the things that one needs to balance. If you want to lodge a check, do so immediately. If you don't, then I think that is equally valid a response as well.
Thank you very much. So if we draw the strings together, or threads together, I should say, in terms of our 3 takeaway points, I think, first of all, the reliefs that are available are a complicated patchwork, as we described. It's well worth ratepayers looking at the whole picture and seeing whether there are reliefs available that they're not taking advantage of. I think that must be a prudent step for people to take. In terms of appeals, how would you phrase the takeaway point, Tim? I think you probably already covered it to some extent, but just to underscore it.
Yeah, I think if you are minded to lodge an appeal, requesting a reduction because of the effects of COVID-19, do it immediately.
Thank you very much. And finally, because although lawyers love these sorts of points, it seems that the lawyers may not be involved in debates over what is a material change of circumstance in this particular context, because happily it may be that there's agreement on this, but no one can really second guess how the courts or tribunals might view matters if it ever comes to that. I think that's another fair point to make.
I agree.
Great. All right, Tim, thank you so much indeed. That's been terrific. Thank you everybody for listening and watching, those that are still with us. Please, if there are any questions that arise, do send me an email, cmoys, M-O-Y-S, @radcliffechambers.com, and Tim and I will endeavour to answer them for you.
We will.
Thank
Thank you.
Tim. All the best.
Bye-bye.